Let's continue with reaction then. Bring in Lawson, Naidoo, the director with Casac. That, of course, is the Council for the Advancement of the South African Constitution. He joins us now live. And Lawson, great to have you. We must admit up front that we don't really have the reasons for this judgment, but we do know it was split three ways. What's your first take of how this has gone, especially when you consider what's at stake?
Good morning and thank you very much. Yes, I suppose it was a bit of a surprise that there were three separate judgments, two concurring in favor of granting of the interdict to the president and a dissenting judgment, but we've yet to see the reasons from of those judgments. But this is a victory for the president. It means that the parliamentary process, at least the substantive part of that process, which involved the actual inquiry, the calling of witnesses, etc., will be placed on hold pending the president's review application, the main application, one can say, in which the president is challenging the report of the independent panel. Now, that matter will be heard in early September, and once judgment in that case is determined, then we will really know the way forward.
Yeah, and let's speak about what that way forward may look like. And I suppose this is a question around the president's strategy ultimately. If he does succeed in reviewing this panel report, which are the grounds really for the establishment of this committee, does that throw everything out essentially?
It would, if the president succeeds in his review application in getting a court to set aside effectively that report of the independent panel. Then there would be no basis for continuation of the impeachment process in Parliament, and it would come to a halt. If, on the other hand, the president is unsuccessful in that review, then the work of the impeachment committee will proceed into its substantive part, as I say, the calling of witnesses and testing the evidence against the president in respect of the charges that were set out in that motion that was passed by Parliament in 2022.
Yeah, we do know, of course, that, or perhaps it's worth asking it as a question, outside of making assumptions, because this was a high court ruling, I imagine that those who are challenging the president's interdict application do have recourse to appeal. Is that something you reckon they'd consider doing?
Well, in an urgent application, there's no scope for an appeal. There may be appeals that emanate from the main review application decision, but for now, this is a final and binding order in terms of the interdict.
Fair. The other question that comes up is, in the event, or rather considering that the president may be successful in his review application, does it make sense for the committee to continue with other aspects of its work in a context where it might all be for nothing? Again, that's if the president succeeds in this next step.
Yeah, I mean, that's debatable, and that's an issue that the committee will have to grapple with when it meets again next Wednesday. They're due to meet next Wednesday to finalize the appointment of evidence leaders, and secondly, to finalize the terms of reference for the work of the impeachment committee. Now, those could likely both continue, and in fact, certainly in respect of the latter, the determination of the terms of reference. That may be something that is actually quite useful because it would pave the way not just for this impeachment process, but for any future impeachment process that Parliament may engage in. It is work that will not go wasted. However, it's more debatable regarding the appointment of evidence leaders. And I presume that Parliament, even if the committee decides on who they want as the evidence leader, that the actual finalization of those arrangements will await now the finalization of the review application.
Yeah, I'm no legal expert, Lawson, but from where I'm sitting, this is the second time that a court in the country has essentially told Parliament what to do. And I suppose the lingering concern for many people who might perhaps share the sentiment is, concerns around this concept of the separation of powers. Do you reckon we're flying a bit close to the sun, or, are the courts very much empowered to have done what essentially has happened over the past couple of weeks?
Well, in fact, that's the very nature of the separation of powers between the three arms of the state. There are no clear lines of delineation in terms of the separation of powers, and where there is a difference of opinion between the legislature and the executive, as there is in this case, it is precisely the design of the Constitution that empowers the courts to be the final arbiters in this matter. In the same way as the Constitutional Court, in its judgment in May of this year, said to Parliament that one of its rules was unconstitutional. So, those who took that case to the Constitutional Court seem now to be arguing that the court shouldn't interfere in the work of Parliament when they actually asked the court to interfere earlier. So you can't have it both ways. The courts do have limited jurisdiction to intervene where Parliament has not followed legal or constitutional principles. And in a case like this interdict application, where the courts have said, well, the president's rights not to be unfairly prejudiced trump the work of Parliament, albeit for a limited period of time.
Fascinating. Certainly live in interesting times. Lawson, Naidoo, thanks very much indeed for giving us your first take on this. Lawson, of course, is the director at Casac.